Mr. Hernandez, you're charged with evading arrest or detention. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 19, 2025, at approximately 11:17 p.m., the officer was dispatched to a discharge of a firearm call on Tilbury Woods Lane. Multiple calls stated there were multiple gunshots in the area, and while servicing the area, the officers were flagged down by a citizen who stated she heard multiple gunshots and a green sedan sped off. Multiple citizens provided video footage.
We'll pause right here. Did you catch that? An untraceable AR pistol tossed mid-chase? That's what we call a ghost gun. And yes, that's a huge legal red flag. No serial number, no accountability. Question is, can they prove it was his? Keep watching.
And the officer saw a vehicle that matches the description parked illegally in front of a residence on Moss Springs Court Road, and multiple males exited the vehicle. The officer then initiated a traffic stop, and the driver and passengers began evading on foot. Officer ran after all three males for 100 yards, and all were detained by the officer. The defendant and others admitted they saw emergency equipment and decided to evade on foot. Surveillance video showed the defendant throwing an AR pistol with no serial number in front of the residence, and surveillance video matched the defendant's clothing.
Saying our defendant here was seen throwing an AR?
Allow me to read the DIM to confirm that it is.
Sure. They filed a tampering. Am I right in assuming that that's the serial number?
Yes, Judge, it is this defendant throwing the AR, and the firearm had no serial number. Yes.
How can you impute the tampering because it's a specific intent crime, right? Unless you have an admission or something like that, something that I have. But you know what? That's not even my forte. It's like we're doing the evading right here. So
fighting upstairs, gonna
I
fight
gotcha.
down here too. So you can already expect my issues with this case already.
No, you're 17. You're now starting your life. This is not a good way to start. You know, you only have two ways that you can go. You can go up or you can go down. Life doesn't get easier the older you get. It only gets more difficult. You get bigger, fatter, you lose hair. It doesn't get easier. And it starts with school. Stay in school. Don't hang with dogs. You're going to get fleas. Do you understand? Mr. Hernandez, you are not to smoke weed. You're not to use alcohol. And I'm making that a condition of your bond. I don't want you to have any possession of any weapons as well. Do you understand? If I find that you're in possession of a weapon, I'm going to revoke your bond. I'm going to put you in jail. You're going to finish school with me. You understand? Did they impose any other kind of restrictions up there as far as like curfew or anything like that?
They did not. At first, he had an ankle monitor with the curfew. I asked the court, they agreed to take it off. So his mother and him are gonna go after this court proceeding to get that removed.
Is mom here?
Mom is here outside with his younger sister.
Okay. Make good decisions, man. Once you start racking up convictions, I'm telling you, it's over. It's not going to get easier. You understand? We've given you a lawyer. It is your responsibility to stay in touch with her. She's great. She will help you out.
Let's talk real life for a sec. This judge isn't just handing out warnings, he's laying out a roadmap. 45 days, clean test, or it's jail time. But let's be honest, will this young man actually follow through, or is he just nodding to get out the door? Drop your predictions in the comments below.
If you're not listening to her, you take off. I can't find you. You pick up a new case. I'm going to put you in jail. No more PR bonds for you. Do you understand? One more thing. I will test you in about 45 to 50 days. And if I find that you're smoking weed, it's not going to go well for you. Do you understand? You will get tested. Be ready. So I don't care what you're doing. If you stop if you stop doing anything that you shouldn't be doing now, then you should be fined in 45 to 50 days. But if you continue to use, or if you smoke, it's not going to go well. You understand? Okay.
Thank you.
Thank you so much for coming. We got you. And then anything you need, whatever you need, just come back and we're happy to help.
Thank you, Judge. And just one thing real quick with the statement.
Mhm.
I know there's other people that were in this vehicle allegedly. Do you have any names for them? Can you,
I can see.
if I circle back around from you?
Oh, co-defendants? That's a good, because you know what?
Well, that's part of my issue with both of these cases.
And Your Honor, it does not appear there's any connected cases.
So I have,
So
yeah, that's my issue with the tampering. That's my issue with this case.
They got them all, right?
That's what they say.
Maybe just because of the surveillance shows allegedly one being thrown and that's why they only went after. Perhaps, I don't know. But
I won't fight everybody too crazy today, but probably the next day. Yeah.
well, I'm with you. You know, whatever you need, just
Thank you, Judge.
make good decisions. That's all we're asking you to do. All right?
Thank
Okay,
you very
guys,
much.
thanks. You got it. Mr. Venegas, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. I have previously found probable cause on this case. I'm ordering you now as a condition of your bond not to participate in like-kind activity. If I find that you're racing, reckless driving, acting a fool on the highway, number one, I'm going to revoke your bond, put you in jail. The second thing is I'm going to take away your privilege to drive. Do you understand?
yes, Your Honor.
Do you see if he has a license?
Still running it, Your Honor. For some reason, slow.
Mr. Venegas, you are not allowed to drive unless you have a valid Texas driver license and liability insurance. That is also a part of your bond conditions. If I catch you driving and you don't have a license or you don't have insurance, it's not going to go well for you here. Do you understand?
Your Honor.
Okay. You have a lawyer. It is your responsibility to stay in touch with him and he'll tell you when you have to come back. If he tells me he can't get a hold of you, then I'm going to issue for a warrant for your arrest. You pick up a new case, act a fool in the free world, I'm going to take it away.
I'm able to run it right now, Your Honor. It's not letting me on our system.
So can you follow the same conditions on the racing that we
Same
did?
racing conditions, yes, Judge.
All right, so I'm going to have you sign a reset. After that, we'll have you take a seat in the jury box. We'll get your bond conditions. You have to sign it, and after that, you'll be free to go.
Good morning, Your Honor.
Morning.
Wanted to approach on behalf of Chasten Blackburn regarding probable cause. I have issues with probable cause in this case, Your Honor.
Okay, let's do it.
So officers were conducting an unrelated fatal accident investigation when they observed the defendant's vehicle traveling at a high rate of speed towards the blocked portion of the roadway. The officers saw the defendant disregard a barricade and were able to successfully get the defendant to stop by shouting verbal commands and utilizing their flashlights. Upon contact, the officers observed a moderate odor of alcoholic beverage, glassy eyes, watery bloodshot eyes, and slurred speech. The defendant admitted to having 3 drinks at a nearby bar and was temporarily detained. Standard filtered righties were conducted, HGN 4 out of 6, walk and front 4 out of 8, one leg stand 2 out of 4. DICs were read and the defendant consented to breath. The results were .086 and .084.
Your Honor, when you turn on the video and it's between,
But remember, this is probable cause. I don't get access to all that stuff.
I understand that, Your Honor, but when the officer basically decided that he's going to arrest her, basically he puts her in the vehicle and before any investigation is done, he says, I'm charging her. This is prior to basically any.
A defense attorney argues against probable cause using video evidence, but the judge reminds them it's not a suppression hearing. This is such a classic courtroom clash. Defense tries to challenge the arrest by dissecting the officer's video behavior, but here's the catch: that's suppression hearing territory, not probable cause. Legal nerds, sound off. Do you agree with the judge holding the line here?
Any field sobriety test being done, she didn't have any slurred speech, Your Honor. No bloodshot red eyes at all. He said all the buzzwords to trigger probable cause. I'm asking the court to watch the video for 5 minutes, Your Honor.
No. That's in for a suppression hearing. This is a mere probable cause, right? So because I have to give them the ability to respond to your arguments. We can't do that in a probable cause. Like, you know what I mean? So if you're saying it is as it is, see if they'll do a dispositive motion to suppress, where if you win, they'll dismiss, but if you lose, you got to plead, right? Otherwise, we can set it. But, when you start getting into the video, when you start getting into the minutia of, well, she really didn't have this, she really didn't have that, I have to give them the ability to respond to that. I can't just rule on it, whether, there was an actual traffic infraction, that's like probable cause or not, right? But when you start getting into the actual details, everything, I mean, that's for, either a suppression or for trial.
That's fair.
So ask them if they're good for, dispositive. That's something that you want to do. Let me see. It's only 60 days old, so you've got some time, I'm happy to do how, go forward with however you want to go forward, but for probable cause purposes, you're getting into argument, right? And I can't give them, I have to give them the ability to respond, Okay, sorry. Okay, hey, what's up? Hey,
Morning, Your
hi, how
Honor.
are you?
I'm here on Miss Belén Ibarra.
The last,
Ibarra.
Ibarra, okay. What's the word?
So, I guess first for bond, she has no bond set in this case because she was on no bond for the felonies last time we were here. But the state is unopposed to a PR bond in this case because
She's being held at no bond on the upstairs.
I know, and
So-
the felony attorney is working on that. They resolved the felonies on Friday. And
They
the
resolved-
bond was not relitigated up there.
She's
I'm
going
just
into
on
a
the
PTI. She's going into like a like a 1-year PTI upstairs. And as part of that deal, we're gonna get rid of our misdemeanor, but obviously she needs to get out in order to get into the PTI and everything.
The felony attorney knows about the bond issue. I don't know when she plans to address it, but I'm just here to get her out on the misdemeanor.
Since it's gonna be dismissed one way or the other with the felony PTI. So I just want to make sure that, our case isn't, holding up the felony offer essentially.
Is she here now? Do we
Yeah,
have
she's
her?
in the holding cell.
Do you mind bringing her out? I mean, they don't even have a date set upstairs though. It's
That's
set for
I know,
126.
I've spoken to the felony attorney. It was a misstep on her part for sure, but I spoke to the felony attorney and she will go approach on it at some point. I mean,
Are you anticipating a PR bond upstairs too?
I would assume so, yes, because she has a PTI, like the felonies have been resolved, so I would assume,
Never
yes.
assume anything,
I
you
know,
know?
I know, and I can't speak for what happens in the felonies. I'm only on the misdemeanor, Your Honor, but,
And I just see that the agreement's is in deeds and everything, so.
Yeah.
It looks like we're moving towards that.
yeah.
I just want to make sure that we don't.
When do you want to set it for? Do maybe like a week
Yeah, that's fine.
and we'll see. Okay.
That's fine.
Does she have history of like flight? Do you know? Because she's got two.
Has no
prior-
history of flight. She lived in Houston most of her life. She is pregnant right now. She's 6 months pregnant, and essentially, we just kind of want to.
She has
Get her
two
out.
prior assault cases. Both of those, any flight in respect to those cases?
I'm not, I actually ran over here.
I don't think, so. Based on what district clerk shows, no, Your Honor.
Let's take a look. I don't see.
All right, go ahead and sign.
So she only has one prior assault. It looks like that one was dismissed. And
Yeah.
this new one here, looks like it was charged assault of a hospital personnel, right?
Yeah, that got dismissed on Friday.
Did they refile it as? Okay,
It just got plain dismissed, and then the PTI is for the assault on a public servant, I think. It's a mental health case, Your Honor.
I'm down with you. I'll grant you a PR bond.
Okay, thank you.
The only thing I'm gonna ask is that she stays in touch with you, right?
Yes.
I'm not gonna continue to do this. Like if she gets out, she just takes off. I'm not gonna do it again,
Yes,
and I'll
I
admonish her
understand.
as such. So,
Thank you, Your Honor. I guess she'll still come out, right?
yeah, I need to admonish her.
Yeah.
Who is our CW?
CW,
Hold on a second. We'll get there.
yeah.
Colin,
Mr.
tell me, what you got?
I have a Sarah Castillo, Judge.
Okay,
That's the one where we were trying to get the records from the sheriff's office. They finally got them to me. And
you have everything you want?
I haven't been able to get through it all. It's like almost 600 pages.
Second, I didn't, thought it was gonna be long. Okay, good. Blessing. Do you speak English, ma'am?
Yes, sir. Yes, Your Honor.
You see, Bar, I want you to understand and appreciate that you have a lot of lawyers that are going to bat for you now, trying to help you even get out. Your lawyer here is asking for a PR bond. You even have the state that's in agreement to get you a PR bond. The only thing that we're asking you to do is be safe to our community. Don't pick up any new cases and stay in contact with your lawyer. Right now, I'm going to grant you a PR bond, but I'm not going to do this over and over and over and over and over. I'm going to give you one chance to get out there and do the right thing, make the best of the chance that you're giving. But if you get out there and you just take off and you don't stay in contact with anyone and you pick up a new case, all bets off. Do you understand?
Yes, Your Honor.
I'm not asking for much. All I want is my community to be safe and for you to stay in contact with counsel. That's it. Okay, so I'll grant you the PR bond. Looks like the bond is already set. We're going to set it out for a week because you're still at no bond upstairs, so we don't know what's going to happen in your felony case. So we'll set it off for a week and then we'll go from there. Okay?
Yes, Your Honor.
Do you have any questions?
Yes, Your Honor.
So tell me about this one here. Who's the complaining witness?
Dating relationship, boyfriend.
Okay. Does he want to have contact with her?
He's not, we haven't really been, he hasn't been cooperative with, so I wouldn't be able to tell you what he wants other than to drop charges, really.
So I want you to understand that I am going to grant what's called a magistrate's order for emergency protection that identifies Mr. Rodriguez as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072, which is the stalking statute. You cannot threaten, harass, use another person to communicate threat or harassing behavior, and you cannot be in possession of a weapon. Do you understand?
Yes, Your Honor.
I'll take off the residential restriction just in case, but everything in the MOAP is stuff she shouldn't do anyways. All right, understand.
Yes, Your Honor. Thanks.
Judge, I just had a quick question. We're set for trial tomorrow in ERD on a family violence case. And I just wanted to know logistics wise, would we pick tomorrow and then start Wednesday? Or if we have a jury tomorrow, do
Are
we
you
just?
really gonna go?
I mean, it sounds like we're gonna go.
You hear this?
Yes, Your Honor.
I've got 7 other cases set for trial as well tomorrow in here.
Okay.
So let's see which one actually
Yeah, let's see
goes.
what the trial-
So, but technically we pick on a Tuesday, everything starts testimony on a Wednesday, and then we go. That's the way. So, yes, thank you.
Thank you.
Mr. Arseno, you are charged with interference with the emergency request for assistance. You are facing up to a year in jail and or a $4,000 fine. It seems that probable cause has already been found in this case.
Yes, sir, Judge. I don't know why we're here, but,
Because he bonded out.
Oh, yes,
He's
sir.
been, I guess he's been AWOL, right?
no, sir, he's been in custody, Judge. He had a felony, assault of a family member that was dismissed, last week,
Okay,
and that's why he got out.
all right. So are there any kind of bond conditions that you guys would like state?
So for this one, just standard conditions would be fine with this type of case. So, and there's no contact for this,
Who's the complaining witness in
His mother.
his mother, Judge.
okay. Is that the complaining witness that was in the felony as well?
That's correct, Your Honor.
Okay, so I'm ordering you not to have contact with this person. Do you understand?
Judge, if I may, I provided the state with some information relative to that. The complaining witness in this case is not willing to go forward. She provided a letter to me, which I have already given to the state. She's requesting that the case be dismissed.
The state would not be opposed to no threatening or harassing contact at this time. And just give us another date to reset to look at the 911 phone calls to make sure that.
Okay, so the case is 180 days old. It's time. So I'll give you a
Okay.
week.
Yes, Judge.
So I'm ordering you not to have any threatening or harassing contact with the complaining witness in this case and not to be in possession of weapons. If I find that you violate these conditions, I'm going to revoke your bond, put you in jail. Do you understand? I'm not asking for much. Now, your case is old. It's time to figure out what we're going to do. So I'm going to give the state a week to get everything done, wrapped up. They're going to put an offer on the case. The next time we come back, you must either accept the offer or I'm going to set your case for trial. Do you understand?
Yes, sir.
Okay, so do you mind filing those conditions, please?
Yes, Judge.
All right, we're gonna have you sign the conditions. After that, we'll see you in a week. We'll go from
Thank
there.
you, Your Honor.
Okay, thank you, Mr. D.
Yes, sir.
You are not allowed to drive. Do you understand? If I find that you pick up a new case or another third case, I'm gonna go nuts on all of the bonds. I'm also going to test you 45 to 50 days from today. You're not to use marijuana at all. Do you understand? If I find that the next time I test you and you test positive, it's just not going to go well for you. You understand? You've given your lawyer, there's just no more excuse. If you get your license and insurance, Mr. Jackson, I will happily take this restriction off. All I'm asking you to do is follow the law. I'm not asking you to split the atom here. Really.
And Judge, we're working on it. We have a out of state fine or suspension, but we cannot figure out what state it comes from at the moment. So we are
Call DPS, you know.
Yeah. Because they're even
You
when they
can
run.
call DPS. Have I given you the phone number?
I don't think so, but
Hold on.
I think it's in Jacksonville.
Do you mind giving this to me? This is the number to the driver's license division for DPS. When you call, you have to call at 7 o'clock in the morning. Do not call at 8. Do not call at 9-102 because you'll never get through. Right when the phone line's open, call them. All you have to do is ask them, what do I need to do to be able to get my license? And then they'll tell you. All right, I'm gonna have you come up here, promise to us that you're not gonna drive, then I'll get you to Victoria Sign a reset. You'll get with Felicia if your bond conditions, and after that, you're ready to go. All right, good luck, guys. You got it. Ms. Johnson, you're charged with making a false report to a police officer. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. On January 19th, 2025, at approximately 1:56 p.m., the officer was dispatched to a child custody dispute at a residence in Harris County, Texas. The officer made contact with the defendant's husband, who requested a report be completed because the defendant did not meet him at a scheduled time and location. The officer made contact with the defendant at 4:45 p.m. via the phone, and the defendant was advised about the husband's request for a report. The defendant became upset and stated she was going to call the defendant's probation officer and say what she needed to say to get his probation revoked and serve 2 to 10 years in prison. The defendant stated she had video footage of the husband assaulting her last month on the phone, and she was going to call and have a deputy come to the residence to pursue charges because he completed the report. At approximately 5:37 p.m., the defendant made a family assault call, and the call slip stated, "See reportee," in reference to husband cussing and pushed reportee. The officer, who had previously contacted the defendant, arrived at the family assault call at approximately 6:02 p.m. and made contact with the defendant. The defendant stated the husband pushed her on 2 separate occasions in January 2025, and the defendant then stated the husband did not punch or push her, he merely brushed against her and admitted it was not intentional. The officer asked to see the video the defendant stated she had. The defendant denied making that statement, and the defendant then admitted to making the statement and stated she did not have a video, but the daughter was present. The defendant stated she did not feel pain, did not have visible injuries, and wanted to pursue charges. The defendant then attempted to change statements again, stating she never made a call for service. The officer read the call slip, and the defendant stated dispatch did not hear her correctly, and that was not what she meant to say. The defendant further denied making a statement regarding the husband's probation. The officer replayed a body-worn camera video of the defendant's statement while on the phone, and the defendant admitted she was not telling the truth.
All right, ma'am, I'm gonna find if there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. Do you understand? That is the gentleman in this case. If I find that you have contact with this person, I'm going to revoke your bond. Look, I can provide you a lawyer today. You can explain your side to the lawyer, but I've got a bunch of DAs here. Anything you say, they're going to try to use it against you to prove guilt. Just don't. I will give you a lawyer. Just explain your side to the lawyer, and then they can go talk to the DAs on your behalf. But I don't want you to say something where you put your proverbial foot in your mouth, you know? Don't. Just. So what I would do is I'm going to have you sign a receipt of Victoria. I will have you then take a seat in the jury box. I'm going to find you a lawyer, and then you can explain your side to the lawyer. Okay? Let me see one thing real quick.